I'm going to talk to you about conduct of arbitral proceedings in India. There have been a lot of webinars, and I know you're already tired of attending webinars, and many people have lost interest because the season is almost over. Lockdown is perhaps going to end, and I'm hoping that you're all keeping safe. You are working from home and trying to be productive. The reason why I want to speak on conduct of arbitral proceedings is because I don't think you will find this in any book and you will be taught this in your school, because the idea is that unless you get a first-hand experience and you get exposed to a proceeding, you would perhaps not be in a position to find out what is the actual procedure which is adopted while conducting an arbitration proceedings. I would like to start from the Arbitration Act itself. If you look at Chapter 5 of the Indian Arbitration Act 1996, it talks about conduct of arbitral proceedings in India. If you see sections 18 to section 27, there are various provisions which have been given which are necessary for conducting an effective arbitral proceeding. An interesting beauty about arbitration is that party autonomy plays a very vital role. It is the key feature of any arbitration. Party autonomy basically means freedom of parties, which supersedes everything. And that makes arbitration more lucrative, more attractive, because parties can choose how they want to conduct their proceedings. Many times you will see certain provisions in the Indian Arbitration Act which start with unless otherwise agreed by the parties. The reason why these provisions, these sections start with these three words is because parties' freedom, party autonomy will supersede the section. Meaning thereby, if a section starts with three words, unless otherwise agreed by the parties, then it means that whatever parties have agreed, that will be superseding anything else, even the section itself. So that is the reason why I wanted to first highlight it. Now, how do you get into an arbitration? As you all know that in any agreement between two parties, if you want it to be referred to an arbitration, and if you want your disputes to be resolved through an arbitration, then the only way to do this is by adding an arbitration clause. Now, what is an arbitration clause? An arbitration clause is basically like any other clause in a contract, wherein you put the dispute resolution mechanism, because disputes are inevitable. And when you are entering into an agreement, you know that disputes may arise. Therefore, you choose a mechanism which is an alternative dispute resolution mechanism because you do not want to go to the court. And you decide that, look, in case tomorrow a dispute happens between you and me, we will be referred to arbitration and we do not want to go to the court. Now, why parties choose arbitration as a dispute resolution mechanism and they do not choose court? Because the protracted litigation, because of the long dates which are given in courts, because too much of technicality in courts, sometimes getting a matter listed becomes a task. And it's not flexible, strict rules of evidence, strict rules of CPC. That is one reason why parties find it sometimes inconvenient going to the court. And some parties perhaps find that arbitration is very expeditious, speedy resolution of dispute, and they feel that it is less technical, flexibility, party autonomy. Parties will decide how to control the proceedings, how to resolve the disputes. And most importantly, the reason why parties feel that arbitration is better is because they find it to be cost effective. Now, once you draft an arbitration clause, the next step is, how do you commence an arbitration proceeding? So the prerequisite for commencing any arbitration proceeding is that there must be a dispute between the parties. Now, who's a party? If you look at section 2, party is any party which is a signatory to the agreement. So the party that has signed the agreement will be treated as a party. That is how it is defined under the Arbitration Act. Now, once a dispute arises between the parties, then a party which is aggrieved gets gets a right to initiate arbitration proceedings. Now, how do you commence arbitration proceedings? The first step is by sending a notice under Section 21, wherein you will write the whole facts and you will state what breach has been caused, what provisions of the contract have been breached by the other side, and you will send a notice invoking arbitration, wherein you will refer to the arbitration clause and you will say that, look, disputes have arisen between us, and because there is an arbitration clause, the matter may be referred to arbitration. Now, interesting thing is that as per Section 10 of Arbitration Act, the number of arbitrators can only be an odd number. It cannot be an even number for obvious reasons, because if the number of arbitrators is 2, then it means that what if one person gives in favor of the claimant, the other gives in favor of the respondent? So there'll be no conclusive adjudication. Therefore, always the number of arbitrators has to be even, 1, 3, 5, whatever the parties can afford. And how do you decide the number of arbitrators? It depends on the stakes involved in the matter. If the stakes are too high, because eventually the arbitral tribunal is going to charge way too much if there are 3 members. So make sure that only if the amounts involved in the dispute are extremely high, on the higher side, then you can afford a tribunal of 3 members. Otherwise, ideally, a tribunal consisting of a sole arbitrator is the best deal. As you're aware that arbitration is of 2 kinds, one is ad hoc and the second is institutional arbitration. Ad hoc arbitration is the regular arbitration which happens in India. Like, I think more than 90% of arbitrations in India are ad hoc arbitrations, wherein there is no institution involved. Parties decide everything. They decide the venue. Everything is managed by the party. There is no intermediary institution which is involved for making arbitration convenient. On the other hand, the institutional arbitration, for instance, Delhi International Arbitration Center, it is an institution which provides a platform for conducting arbitration, therefore making it very smooth and convenient. Similarly, if you look at the international institutions, International Chamber of Commerce, Singapore International Arbitration Center, London Court of International Arbitration, HKSIAC, Mumbai Center for International Arbitration. These are all institutes which are providing facilities for conducting arbitrations. And in most of international arbitrations, you see that the arbitration is institutionalized rather than ad hoc. So this was a classification on the basis of conduct of arbitral proceedings. Apart from that, there are 2 kinds of arbitration, which is the domestic arbitration, which is between 2 Indian parties, no foreign element involved. And the other kind of arbitration is international commercial arbitration, wherein a foreign party or a foreign element is involved. The moment there is a foreign party, the arbitration automatically becomes international commercial arbitration. Now, why there is a distinction in the Act? So if you look at Part 2 of the Arbitration Act, so Part 2 governs the international commercial arbitration. So far as the domestic arbitrations are concerned, they are only governed by Part 1 of the Arbitration and Conciliation Act, except 3 provisions which are present in Part 1, namely Section 9, Section 27, and Section 37(3)(1)(a). These are the only 3 provisions which, after the amendment of 2015, on 23rd October 2015, they were applied even to Part 2. So always remember this. Otherwise, the general norm is that Part 2 will govern the international commercial arbitration, that is the foreign seated arbitrations. Now, when you have to invoke an arbitration, you send a notice invoking arbitration. And the first step, always remember, the first step is sending a notice under Section 21. Many times I've asked this question. Okay, the exceptions are, Urvi has asked me a question, what are the exceptions? So after the 2015 amendment, if you look at Section 2, Section 2.2, there has a proviso was added to Section 2.2, wherein Section 9, which is the interim relief by court, Section 37(3)(1)(a), which is regarding appeals, and Section 27, which talks about court's assistance in taking evidence. So these are the three provisions which were made applicable even to Part 2. Moving on, so a lot of times the question is asked, when does an arbitration proceeding start? This sometimes a lot of students of mine have said, sir, it starts when you file an application in the court for appointment of an arbitrator. Some people say, no, it starts when dispute arise. And I would like to ask you this question, but because due to the paucity of time, what we'll be doing is I'll be speaking first for 30 minutes. And when I sum up, we'll have an interaction chat about this. So basically an arbitration begins, it commences. If you read the language of section 21 of the Arbitration Act, always remember an arbitration commences when a party sends a notice invoking arbitration to the other side and the other side receives it. That is the date on which the arbitration commences. That is very important. So if you look at the heading of the section, it says commencement of arbitral proceedings. So that is when the arbitration proceeding will begin. Now, once you've sent the notice, what will happen? The other side obviously will reply to your notice and they will deny your claims. Perhaps they will say that even I have suffered losses and I'm going to entitle myself to some claims. So now you both will be in a disagreement and both of you will be claiming that, no, I have to pay you. The other side will say, no, you have to pay me. So these arguments will go on, and eventually, because parties will perhaps not agree on the name of an arbitrator. And who's an arbitrator? Arbitrator is the judge who decides the arbitration. He's called an arbitrator. Mostly retired judges are invited as arbitrators in matters. Now, the moment you consider what is going to be the step for appointment of an arbitrator, the only way left is, because parties are not agreeing on a common name, you will have to move a Section 11 application under Section 11(6), wherein you will file an application before the court. Court means only the High Court in case of domestic arbitration and the Supreme Court in case of international commercial arbitration. Once you move an application for appointment, the court will appoint an arbitrator, and that is when all of this will come into play, that how the proceedings are to be conducted. If you move on, the first hearing will take place where the arbitrator will chalk out a schedule. It is called a procedural hearing ordinarily, wherein the arbitrator decides what is going to be the future course of action. What are going to be the timelines which are to be met? What is the procedure which is to be adopted, etc., etc. So all these ancillary things are discussed in the first hearing. It is important to note that an arbitrator, initially when he enters the reference, has to give a disclosure. There's Schedule 6, if I'm not wrong, in the Arbitration Act, which gives a mechanism. There is a procedure, the way you have to write a disclosure, wherein you will say two things. It is in line with Section 12. The arbitrator has to say that there are no circumstances which will give rise to any doubts as to my independence or impartiality. The second thing that the arbitrator has to say in that disclosure is that I will be able to devote sufficient time to the arbitration, because under the Act, there is a time period of 1 year which is given to finish an arbitration. When the arbitrator holds the first hearing and he decides a procedural order, he will dictate a procedural order wherein timelines will be fixed. Obviously, the person who is claiming the amount is called the claimant, and the person who is going to respond to the claims is known as a respondent. Sometimes we see that a respondent may also have claims against the claimant, and these claims are called counterclaims. Therefore, making the respondent a counterclaimant also. So he's a respondent and a counterclaimant. Now, the first thing which is to be done is that, okay, I will tell you what Section 18 says. Section 18 talks about equal treatment of parties. So like I said, if you look at the Chapter 5 of the Arbitration Act 1996, it starts with equal treatment of parties. Why? Because in arbitration, principles of natural justice are given utmost importance. Each party must be given a right to defend himself or herself and must be able to present his case to the best of his ability, and that opportunity must be given by the arbitrator. That's why the very first provision in the Chapter 5, that is Section 18, talks about equal treatment of parties. If you look at Section 19, which is the next section in Chapter 5, that is Conduct of Arbitral Proceedings, it talks about determination of rules. What is going to be the procedure to be adopted in the arbitration proceedings? It's one of the very important features of arbitration, which is my favorite personally. I feel the best thing about arbitration is that the strict rules of evidence and code of civil procedure do not apply to arbitration proceedings. However, the principles behind the same apply, meaning thereby that you will not lose a case on extreme technicalities. Only the principles behind the evidence and CPC will apply, and the strict rules which are followed in a trial court are not to be followed in respect of admissibility, in respect of filing, etc., etc. Because a lot of times you see that in courts, battles are lost, the matters are lost due to technicalities, even if you have a very good case on merits. So that is where the youngsters and young practitioners face disadvantage, because the seasoned practitioners, of course, have an upper edge. But I don't think that is the case in arbitration, because we are all on the same page. So I have discussed with you Section 18 and Section 19. Now, if you look at Section 20, it is the place of arbitration. So parties are free to agree on the place of arbitration. Okay, one question has come from Sunil. I'll take the question answers later. I will first finish quickly, and then we'll have 20-25 minutes on question and answers, if that's fine with you all. Do let me know if this suits you. The moderator is fine with it, because I don't want to break the flow. Okay, perfect. Thanks, Sunil. So, like I said, Section 20 talks about the place of arbitration. The word seat has not been defined anywhere in the Act. Sometimes the Balco judgment has perhaps considered place as the seat if there is no indication of his seat. Otherwise, in a very recent judgment, which was pronounced perhaps on 13th December, I'm not too sure, in 2019, which is BGS SGS Soma, in that also it has said that the venue or place will be treated as a seat if the seat has not been specified and there is nothing significant which suggests otherwise. So now the law is that currently place and venue, if that is mentioned, then it will be treated as a seat unless there is something significant which suggests otherwise. So one thing which is important to be noted is that parties are free to agree on a procedure. If they are in agreement on a procedure, then tribunal cannot tell them, no, this cannot be the procedure. However, if no procedure has been agreed to by the parties, in that case, the tribunal is free to agree on a procedure that it deems fit. Similarly, parties, as per Section 20, are free to agree on a place of arbitration as per their convenience. But if the tribunal feels, and if there is no agreement of the parties, then tribunal will decide what is going to be the place of arbitration. So this is 18, 19, and 20, which I have discussed briefly with you. Section 21, I have already informed you, which talks about commencement of arbitral proceedings, wherein one party sends a notice invoking arbitration and the other party receives it or gets acceptance of that notice. That is the date on which the arbitration proceedings commence. Now you come to Section 22, it talks about language, that parties are free to agree on the language of the arbitral proceedings. Now, why is language important, and so important that there is a provision, there is a section in the Act for language? I'll give you an illustration. Imagine an arbitration proceeding where one party is a Russian party, the other party is an Indian party, the witness is a French, the arbitrator is a German, what will happen in this? Now, evidence is being recorded in French. Arbitrator is speaking in German. And because of this reason, what happens is that parties do not know what to do. It is going to cause a lot of inconvenience. Therefore, it is extremely relevant that language should be uniform so that everybody is on the same page and it is convenient for the parties. Okay, I think I've got a suggestion from someone. Just one second. Okay, Vibhuti Deshmukh is telling me Mankastu Impex is the latest judgment for seat and venue debate. Thank you, Vibhuti. I may like to add that it's a 5th March judgment by Justice Bhanumati, the one you are pointing, if I'm not wrong, subject to correction. Mankastu was on a different issue, though it considers seat and venue, but it was on a section 11. The law has been settled in the case of BGS SGS Soma versus, I think, NHPC, wherein Justice Nariman has considered the erstwhile judgments in Hardy as well as Antrik's Devas judgment of Delhi High Court Division Bench. Interestingly, both of these judgments, Hardy and BGS Soma, are 3-judge bench. But what the case of BGS Soma says is that Hardy incorrectly applies Balco, which is a 5-judge bench, and does not follow the Rogers-Oshua test. What happened in Mankastu was that there was a section 11 filed. The seat was Hong Kong, and the petition of section 11 was filed in High Court. So the Supreme Court said that because the seat of arbitration is in Hong Kong, the Delhi courts will not have jurisdiction. I think this is what the judgment of Mankastu says, which you have just quoted, subject to correction, of course. My memory is not that great. Okay, now moving on. Okay, thanks, Vibhuti. We are in agreement on this. So, like I said, that language plays a very important role. Section 22 of the language, which of course means that language should be uniform. So when you are drafting an arbitration clause, you must always ensure that you specify the language of the arbitration proceedings. So what we see is that the language of the arbitration shall be English, so that it's convenient for everybody. Now, section 23 talks about the statement of claim and statement of defense. So like I said, that a party which is claiming the amount will have to then file a statement of claim, which will contain all the claims of the claimant and all those supporting facts and documents on which the claimant is relying. It is going to be the backbone of your case. It is going to be the pleading which you are going to plead before the tribunal. Now, once you file your statement of claim, which of course, I mean, generally we take 4 weeks time for it, then 4 weeks thereafter, the respondent will have to file a statement of defense, wherein he will be disputing / countering all the allegations made in your statement of claim, and defense will put his case forth or her case forth in a statement of defense, along with the supporting documents, of course. Like I said, there are cases wherein a party may file counterclaims because the respondent may say, look, he has not suffered any loss. I am the one who has suffered losses. So I am the counterclaimant. So respondent may, in his own whims and fancies, bring counterclaims, and sometimes there may be genuine counterclaims also. So depending on the case to case. Now, when the respondent will file a statement of defense and a counterclaim, the next step is that the claimant will have to file a rejoinder, which is reply to the statement of defense. And if there is a counterclaim, then a reply to counterclaim. Similarly, if there is a counterclaim, then respondent will get an opportunity to file a rejoinder in respect of reply to the counterclaim. So this is the stage of pleadings, because the first and foremost stage is completion of pleadings, which is that all the documents which are relied upon by the parties must be placed on record before the tribunal, along with the pleadings of the respective parties, so that the tribunal knows what the case is, what the dispute is, what the parties are claiming, what is the objection to the claims, etc., etc. Now, moving on, if you look at section 24, it talks about hearing and written proceedings. So the section says it starts with unless otherwise agreed by the parties. So if parties have decided that no, there'll be only oral hearings, then there'll be only oral hearings no matter what the section says. So what the section simply says is that tribunal must hold oral hearings as much as possible. However, if it is not possible, then on the basis of the written documents also, it can be considered. Tribunal may decide if the parties are not in agreement. Otherwise, parties are the boss. They decide how they want the hearings to take place. Section 25 talks about default of a party. Assuming that the tribunal had given time of 4 weeks to the claimant to file its statement of claim, and the same was not filed by the claimant, then in that case, the tribunal may say that because there has been a default of a party, the arbitration tribunal will, of course, terminate the proceedings. Because the claimant did not file the claim, there is nothing to adjudicate, and thus there will be nothing to go forward with. Similarly, if the respondent does not file its statement of defense within the time given by the tribunal, then the tribunal may consider forfeiting his right to file the statement of defense and may treat it as a waiver that he is not filing it and will go ahead and proceed while passing the award without any statement of defense. So long and short of it is that firstly, parties will decide the procedure and the rules that are going to be applicable. If the parties do not do so, then the tribunal is free to decide what is going to be the mechanism, what is going to be the procedure for conduct of arbitral proceedings. Now, if you look at section 26, it talks about the appointment of an expert by the arbitral tribunal. Sometimes what happens is that there are some technical issues involved in an arbitration, and the tribunal feels that, look, I need to involve an expert because assuming that there may be an accountancy issue, there may be an audit issue, there may be an issue of delay, and arbitrator may not be an expert of these areas because he's an expert of law, as mostly the judges and lawyers are appointed as arbitrators. So the arbitrator might consider appointing an expert. So that is the provision which talks about appointment of expert. Similarly, section 27 talks about court's assistance in taking evidence, which means that if some person has to come as a witness because he is an important witness for being present before the tribunal. But interesting thing about arbitration is that arbitrator is the creature of an agreement. Therefore, he is appointed by the parties who are signatories to the agreement. Therefore, he cannot bind third parties to the arbitration. Assuming that I and Vibhuti had an agreement wherein we agreed for appointment of Sunil as the arbitrator. So Sunil will not have jurisdiction over anybody else. He will have jurisdiction only in respect of me and Vibhuti. He can bind us with his orders and nobody else because we have appointed him. Yes, Pintu has asked me a question. Can the name of an expert be decided by the parties in the agreement? See, there are two kinds of experts, party appointed experts and the tribunal appointed experts. What happens is that if the parties want to appoint somebody as the expert, in a way, the arbitrator is the expert that they appoint. I have never seen an arbitration clause where parties are appointing an expert in the arbitration clause because they assume that if disputes will arise, the arbitrator is going to be the expert deciding our dispute. So if I am a contractor who's doing construction matters and Sunil is also a construction contractor perhaps, maybe we would want a retired engineer who's an expert in the subject to be the arbitrator. So we will appoint him as the arbitrator. We would not see an opportunity to appoint him as the expert in the arbitration. That situation may arise in the future when parties feel that, look, the case revolves around delay. I need to bring one expert report of an expert who will be able to help me win the case. Similarly, tribunal may appoint an expert to assist the tribunal in arriving at a conclusion to decide these technical issues involved in the matter. That is what section 27 deals with. Now, 18 to 27, these are the only provisions in the Arbitration Act which talk about conduct of arbitral proceedings in India. Now, I will take you forward because I told you the pleading stage is complete. Once the pleadings are complete and they are filed by the parties, the next step forward is, okay, Thank you. I think the moderator is saying you can ask questions at the end. I will briefly finish. If you give me 10 minutes, I'll wind up because I'm going to give you an overview of the whole arbitration case, how it starts and how it ends. So just allow me to finish in the next 10 minutes, and then we'll have a Q&A quick session. Okay, and I promise I won't exceed my time, because in these times, I know you all, like me, may have become used to comfort during the lockdown. So yeah, I won't take much time. So moving forward, once the pleading stage is over, the tribunal will then move on to the stage of admission, denial of documents, and framing of issues. Now, this stage is very critical. The claimant will file an affidavit, which is called an affidavit of admission denial, wherein all the documents filed by the respondent, assuming that respondent has filed 10 documents with his statement of defense. So the claimant will have to deal with all 10 documents and will either deny or admit the document filed by the respondent. Likewise, the respondent will also deal with each and every document filed by the claimant and will either admit or deny. So assuming that there are 20 documents filed in total by both the parties, and both the parties have admitted 10 documents, like the contract, they both will admit most likely. Generally, they admit because both of them are relying, unless one party is challenging the agreement. So that document which is admitted, it becomes easier for the tribunal to rely on that document because nobody is disputing that document. Because admission is the best form of evidence. That is the basic principle of Evidence Act. That once both the parties are admitting something, it's the best evidence. With, you don't have to look at anything beyond that. You can simply rely on that document. Now, there will be documents which are disputed and denied by parties. So there may be 5-6 documents of the claimant which respondent is denying completely, or is admitting receipt and denying the contents of it, and whatever, and so on. So this is the admission denial stage. And the other stage with this is the framing of issues. Now, tribunal will ask the parties to suggest and propose certain issues involved in the matter. Now, what are the issues? The issues are whether there has been a breach of the contract by the respondent or not. This might be the first issue from the claimant side. It's a neutral issue, is always neutral. It's not a contention. Contention is something which you are contending, which is your argument. For instance, in this case, your contention will be the respondent has breached the terms of the agreement. And if it's a neutral thing, it's an issue, whether. Similarly, respondent will also propose certain issues, which will, important part is that the issues which are being framed, ordinarily the tribunal is going to give adjudication on these issues only. Therefore, make sure that when you are framing the issues, you don't miss on anything critical or on which you want the adjudication of the tribunal. And it is extremely imperative that you consider all the important issues surrounding the controversy and make them part of the issues. So once the issues are framed, the tribunal will then look at both the proposed issues and will finalize the issues involved in the case, so as to narrow down the controversy and to see that we have to stick to these particular issues in the matter. And I will eventually give an award, which is the judgment of the arbitrator in respect of these issues. Once this stage is over, the next stage is of filing of evidence. Why evidence is necessary? Because some parties have disputed the documents. The only way you can prove it is by giving evidence. Now, claimant will give list of witnesses. Claimant will say, I have 2 witnesses or 3 witnesses. Similarly, respondent will say, I have XYZ number of witnesses. And then you file their evidence by way of an affidavit. So this evidence is being given in the way of an affidavit you're just giving an affidavit and signed and sworn by the witness. Now this evidence will be, of course, there'll be a cross-examination of the witness by the other side. This is the next stage. Cross-examination is basically an opportunity for the lawyer of the other side to bring out the facts or to demolish your credibility, your witness's credibility, or the credibility of your case, that the testimony is flawed, and these are to question the veracity of the statements made in the affidavit. And if it's very important that everything needs to be considered, because if you're not cross-examining a particular witness on a point, sometimes you are missing on an opportunity, because that is the only chance you have to bring out the truth and to contradict the witness with the incorrect statements or some frivolous statements made by him. That's your opportunity to bring out the truth in front of the tribunal. It's a very crucial stage for proving your documents or your case, and because the tribunal is forming an opinion during the cross-examination that who's right and who's wrong. Once the stage of cross-examination is also over, the last stage is, of course, which you do day and night in moot courts, at homes, arguments. So written submissions are filed by the parties, wherein you rely on the judgments, which have similar factual matrix. You rely on precedents, and therefore you file a written submission sometimes before the final hearing, which is pre-hearing submissions, and sometimes after the arguments we give post-hearing submissions, depending on the comfort of the tribunal, how they want it. And you rely on the evidence, the questions which are in your favor, the judgments which are in your favor, the clauses of the agreement which are in your favor. So basically everything that you are relying on is there in the written submissions. It is the last and final thing. Subsequent to that, the arbitral tribunal will then pass an award considering the documents on record and the contract, of course. Most importantly, the tribunal cannot travel beyond the terms of the agreement, because a tribunal or an arbitrator is, at the end of the day, a creature of the agreement. Having said that, I think this is the long and short of the conduct of arbitral proceedings. Now you may ask me any number of questions. I'll be more than happy to answer. You can unmute yourself. I think that can be a better way, because we can have a conversation, or you can post your questions, whatever suits you. We have like 20 minutes. I finished quickly. Okay, now.
Hi, sir. So,
yeah,
sir. So, a lot of my juniors have asked me this question.
Yeah.
That even though arbitration is an alternative to litigation, a substantial amount of litigation is involved with arbitration, because it happens under the supervision of the courts. So if one wants to work as an arbitration lawyer, is it necessary for him or her to understand the nuances of litigation? And the sub question to that would be, how different is it to appear before a tribunal than appearing before a court of law? So this is the question a lot of my juniors have asked me. So I would like you to address that, if you can.
Excellent. I think it's a very interesting question. Firstly, I'll tell you that litigation is inevitable. It's a part of, if you are an arbitration practitioner, and if you're planning to do arbitration, then the good thing is that you are also doing court proceedings related to arbitration or stemming out of the arbitration. Firstly, for appointment of the arbitrator, you go to Section 11 in the court. Similarly, if you need any interim reliefs, you go under Section 9. If you want court's assistance in taking evidence, you go in 27. If you need to execute an award, you go under 36. If you want to challenge an award, you go under 34. If you want to file an appeal, you go under 37. If you want to substitute or terminate an arbitrator, you go under 14 and 15. So you have to eventually be involved in litigation, of course, because litigation definitely will arise. And yes, there have been delays on this account a lot of times. And that's why the 2019 amendments, which have come, some of them have not been notified yet, including the ones in Section 11, which talks about the Arbitration Council of India and institutionalizing arbitration in a way and getting appointments done from court-appointed institutions. That will perhaps reduce the interference of courts. And I think that there is a major difference between appearing before tribunal and appearing before courts. Because in an arbitration tribunal, like I said, so what we see in courts, a lot of people say that it's better to take senior advocates with you, and the people who are seasoned, more experienced, and youngsters may not get that that kind of chance or an opportunity to argue. I don't know, some judges and some benches, in my view, do encourage this, but this is a perception, because somebody who knows the technicalities better will be able to get an advantage over you and may perhaps win a case over you. However, the arbitral tribunal is extremely different. In my view, there is less it's not about any technicality. It's very informal. You are not standing and arguing. You're not wearing robes. You're not wearing a band. You are just sitting like this. Like just before this webinar, I finished an arbitration proceeding. That's why I changed the timing from 5 to 5:30. And this is how I was sitting conveniently. So arbitration is very flexible. You may have it in some 5-star hotel, some resort. You may do it at arbitrator's residence. So it's less formal. It is very flexible. It's comfortable. You are having lunch also. Sometimes there is a tea break. So, it's very convenient. Dates are fixed in advance as per the convenience of the parties. And you don't have to wait the whole day like you sit in the court for a matter. And, you can have 6 days hearing at a stretch, which is not possible in court, of course. Sometimes one hearing may take place today, the next hearing may take after 6 months. So, and of course, courts are very, very formal. In court, you can't get a full day hearing. You cannot say, I want a full day hearing as such. But in arbitration, the full day is kept for you. You can argue the way you want. And I think there is less, because there is no strict rules of evidence and strict rules of CPC. So young practitioners like us we are treated at par with the senior lawyers, perhaps. There is not much indulgence which is given to somebody because he's more seasoned. So I think arbitration is a very good platform for youngsters and young legal practitioners. Whereas in court, I feel that it is more formal, and it is, sometimes you may have to wait the whole day and your matter may not be taken up. And there are more technicalities, more procedural issues. Listing a matter is a task. So I think these are the key differences which I feel personally are there in arbitration and litigation in courts. I think there are some questions
very
in the chat box also. Yeah.
Sir, before, sir, we have received some questions through registration. So I would like to address, I would like you to address those questions first. So
Yeah.
I'll just share the screen with that picture of the questions.
Yeah.
Just a second.
Can you read them out to me? I'll try to answer
them.
Yeah,
sure. I'll also put it on the screen and then I'll read it also.
Yeah.
So the first question is, what are the effects of insolvency moratorium in arbitral proceedings seated in India?
Yeah. So I'll tell you, there are 2 judgments of Delhi High Court also, and I think it's a settled law. If you look at section 14 of IBC, if I'm not wrong, either 12 or 14 in my view, wherein it says that all proceedings will have to be stalled. The moment a moratorium is issued, then no proceedings can go on. Whether it is an arbitration proceedings or some suits going on against that company, everything has to be stayed immediately. It cannot go on.
All right. Sir, the second question is, what are the prospective changes that you can foresee in arbitral proceedings after this pandemic? How do the proceedings over video call affect privacy, confidentiality of the parties? And are there any laws to govern it in India or outside?
See, this pandemic, none of us anticipated, and I'm not sure if anybody could see or could foresee all of this happening. So this is all very new. It's all in the nascent stage. And the courts and as well as the tribunal, we are trying to cope up with it. We are trying to take initiative, and because we don't know when all of this will stop. So yes, in my view, the future of justice is going to be online, and video conferencing is going to be the way forward, and perhaps going to be more convenient. I don't see any difficulty as long as I am conducting it. In my personal experience, I find it to be very, because, initially when in courts, the e-filing was introduced, a lot of people used to find it very difficult that how things will happen. But eventually we learned it. And now everything is perhaps being e-filed. There are hardly, judges are not carrying those files as such. So similarly, I think that it will take some time and they will get used to it. Yes, there are some privacy issues involved. But, Government of India perhaps has issued certain notification wherein some suggestions have been given, what apps and what platforms to use, what not to use. And so far as arbitration proceedings are concerned, I think that it is going to be very convenient. But yes, initially there will be some issue, but I don't see any difference. Like I'm talking to all of you right now. I don't feel that it would have been different had I been there in person. As long as technology is there, we should make use of it, and we should be careful. And presently, there are no laws to govern it in India because this is all very new. You may go for IT Act in respect of Information Technology Act is the only act I can think of, but it's not something which relates to the video conferencing proceedings. There are suggestions. There was an article on Bar and Bench 2 days ago. Certain guidelines have been formed by the Supreme Court also. The Delhi High Court has also issued certain guidelines. I don't know of any law as such which talks about how to conduct a proceeding on video conferencing. But yes, today, for instance, Delhi High Court has increased the number of people attending the proceeding to 10. So that's why, yes, slowly we will cope up with it. And I think we will find our way, yes.
All right. Sir, are you aware of any rules issued by the prominent institutes like CIEC or LCIA with regard to the virtual hearing of arbitration?
Yes, I think that some notifications have been issued, and I'm not. I'm being honest. I haven't gone through it in detail, but yes, some statements have been given by, and there was a joint statement also by all the institute that in the COVID outbreak, how they are going to conduct. Yes, these institutions are all ready. All the facilities are there, but I'm saying, like, for instance, even in ad hoc matters, it's very convenient. Like, I can just start a Zoom meeting, and I just invited all the arbitrators. So it's not something which is very difficult or which will make a huge difference.
Right. So the third question is, what are your views on the controversy regarding the new rules to be a certified arbitrator as provided under the 8th schedule?
Yeah. So under the 8th schedule, which has been introduced by virtue of 2019 amendment, which in my view has not been notified yet, the only controversy was, due to which it was criticized at length, was that foreign arbitrators cannot be an arbitrator under the Indian Arbitration Act if this is implemented. This was the impression which people were getting, because Schedule 8 says that it is any arbitrator must be qualified as an advocate under the Advocates Act and must be having 10 years minimum practice. So that's why it received a lot of criticism. However, recently the Honorable Law Minister has clarified that since it is in Part 1 of the Arbitration Act, it is not going to be applicable to Part 2, which is foreign seated arbitration or international commercial arbitration, and thus it is not applicable to foreign arbitrators. Therefore, a foreign arbitrator need not comply with all of this, and he will still be eligible. Otherwise, I think it's a good start to keep a check, because in a lot of matters, people used to appoint anybody with no experience as an arbitrator, and it used to cause a lot of inconvenience. At least some guidelines have been given. So I think it will turn out to be fruitful, but we don't know unless we see how it is implemented. Everything depends on implementation. Yes.
All right. So the last question is, can without prejudice communications be used in arbitral proceedings? Now, this obviously requires another session, but your view on that.
Yeah, I'll try to briefly respond to it. See, like without prejudice communications, confidential proceedings, mediation are also like proceedings before the mediator or a negotiator. All of this ideally should not be used, and it is not acceptable, but people have a habit of sometimes annexing with their statements. So when you are at a stage of admission denial, that is your opportunity where you can say this cannot be admitted because it is confidential or it is a privileged communication, or you can ask the tribunal to perhaps sometimes rule also on that. So yes, without prejudice, when you are writing in the arguments, you can always say this was without prejudice to my rights and obligations under the contract. So there is a reason why you use the word without prejudice, so that it doesn't affect your other rights and your other contentions. So yeah, I mean, that's a matter of argument, and I think it's basic. Everybody knows why you are using without prejudice, and it is accordingly interpreted and used.
All right, sir, we have received 3 more questions in the chat box. Should I read it to you, or will you access it?
Yeah, if you can take off the screen so that I can just.
So I'll read it from the chat. So Urvi is asking, who is eligible to become an arbitrator? 1 second.
Okay, I think there are too many questions.
Any arbitration procedure.
1 second, let me read it. I will just then give them a collective response. Just let me read one of them.
Right.
Because I think there are only 7 minutes left, and I think there are too many questions. So just quickly let me read it, okay?
Okay.
As you know, can the parties have clause in the agreement stating that experts must be consulted by the arbitrator, owing to the fact that it is a technical matter that they are dealing with in the contract, and hence if any issue arises, it will be imperative to consult experts. See, expert appointments, always remember that sometimes parties write qualifications of the arbitrator. I'll tell you how it is done. Parties may say that any arbitrator who will be appointed should be an expert of company law or should be a delay expert. Ordinarily, parties write like that, and that's why there is a ground of challenge in Section 12 also, that if the arbitrator does not possess the qualification, then he can be removed as the arbitrator. So what you have asked is that can the parties have a clause in the agreement? Parties can definitely have any clause. Nobody can stop them. But as I said, arbitrator at the end of the day will decide. You can always move an application, even if there is no clause. You can move an application before the tribunal saying that I feel that an expert must be appointed because it contains a technical matter, and I think that it would be appropriate if you get an expert report. So arbitrator would definitely agree if he feels that this is a matter which is requiring some technical expertise. And yes, if you, like I said, parties can have a clause, but the clause is designed in such a fashion, the way I am saying, that they will say it is the arbitral tribunal will be appointed consisting of an expert. That's the general norm. But yes, they can word the clause the way they want. There's nothing stopping because it is party autonomy. Okay, there was another question by Visalakshi. Sir, how do you think the amended provisions relating to independence of the arbitral tribunal would help in the conduct of arbitral proceedings in times of COVID? Vishalakshi, you are referring to the 2019 or the 2015 amendments? I think you are referring to Schedule 5 and 7. See, it will, conduct of arbitral proceedings will remain unaffected because so far as the independence of arbitral tribunal is concerned, it only relates to the disclosure which is being given by the arbitral tribunal. And as long as the disclosure is correct, whether there are virtual hearings or there are actual hearings, it will not make any difference. So conduct of arbitral proceedings virtually or in person will have no implication on the independence or impartiality because there is no way to keep a check. The only problem is that today there is no mechanism to find out if the disclosure which is being given by the arbitrator, if it is correct or not. There is no database to keep a check. So yes, that's one thing which I think otherwise it won't make much difference if it's conducted virtually or not. Okay, is it mandatory to stamp an arbitral award? Pintu is asking me. Okay, I think there was a judgment of Geo Miller. I think Geo Miller or I don't know what exactly was the name of the judgment, wherein the courts have clarified that any document which is not stamped will not be admissible, and will if you're filing a section 11 for appointment of an arbitrator and the agreement is not duly stamped, then you will have that will be impounded. Same is the case with arbitral award. The arbitral award, you have to pay stamp duty on it, and which is I think in Delhi 0.01% of the awarded amount. Otherwise you can't execute it. Execution will not be possible because then it would fall under public policy angle. Vibhuti is asking me a question. What about the cost? Do we follow the cost after the event, or is it equally divided between the parties? So cost of arbitration is divided equally between the parties, 50-50. Sometimes the respondent says, I will not pay. And if he doesn't pay, his counterclaims will not be entertained. And the claimant will have to then pay the full amount, which will be recoverable in the final award. So when the final award is given, there is a claim for cost also, cost of litigation, cost of the arbitration, and it is fully recoverable if the arbitration, the claimant wins the arbitration. What is the next question? Okay, who's eligible to become an arbitrator to any arbitration? I think there are too many questions. They're just...
Yes, sir. We'll just take one last question.
Yeah.
Anyone you would like to take?
Who's eligible to become an arbitrator to any arbitration proceeding in ad hoc arbitration, institutional arbitration? See, you read the judgment in Perkins matter. There's a case of Perkins Eastman in which the courts have clarified that unilateral appointment of arbitrator is not permissible. In an ad hoc arbitration, if you are appointing an arbitrator, an interested party cannot appoint a sole arbitrator. So that is the law. As long as you are not doing that, you can appoint anybody as an ad hoc as an arbitrator in an ad hoc arbitration. Similarly, if the institutional arbitration is going on, the institution maintains a panel of arbitrators in the institution, and they can appoint anybody from that panel as the arbitrator, unless the court in section 11 is appointing somebody. So that's the norm for appointing an arbitrator. But two things are to be kept in mind. Read section 12 of the Arbitration Act, which says arbitrator. So there is a schedule 5 and schedule 7, which was introduced on 23rd October 2015. If the arbitrator is not falling in those, then he can be appointed. And Schedule 5 will, of course, give rise to his independence, some doubts, and to his impartiality, whereas Schedule 7 will make him ineligible to be appointed. Okay, so I think with this, yeah, we can call it a day. I think unless, I'm not too sure if the students found this to be useful, but we may have another one if need be, because
So
it's a very vast.
this was very useful, sir. Thank you so much for such an informative session. I'm
No, that's
sure a lot
fine.
of students have been benefited from this. And sir, I'll be sharing the recording of this session through a shareable link.
Yeah.